Are you legally responsible for what you signed in a contract if the information in the contract was incorrect? This week's episode coming up now. Hi there, and welcome to another exciting episode of the Conscious Counsel podcast with your host and lawyer, Cory from Conscious Counsel. I am super excited and happy and jazzed up to share with you all of the fun information that's going to help you protect and grow your wellness business with both confidence and clarity. That's the name of the game. That's what this is about. It's what it's always been about. And I love jumping into different stories and adventures from my email inbox and from my world and sharing them with you, because I know that you don't think about the law that much or ever. And if you're listening to this, you probably want to learn more and understand what sort of legal issues can be out there. And the whole fun of me putting these episodes together and taking this time is to share my information with you. So this week, we're talking about what happens if there is incorrect information in a contract. Okay, very big thing. The reason why you should care, as you are a health and wellness business owner, you should be using your own agreements. You're probably signing a lot of other agreements. And I want to go through what happens if the information in the agreements is not ascertained or is incorrect or has not been done properly, because the mistakes can be very grave, as you're going to hear in the story that I share in this week's episode. So essentially, this information, what's at stake for you, could be tens of thousands of dollars saved. And I always want my clients to win. That's all that I care about. All I care about is getting them results. And so I share these stories because it's really important. So the general legal principle when it comes to contracts and understanding what is written in them and what you must be legally bound to with them is that when you have a contract, you have an opportunity to read through it. Usually there's a provision for something called ILA, which stands for, anybody want to guess? Independent legal advice. Okay, maybe we said that, maybe we didn't. Doesn't matter. There's usually a provision that says you agree that you had the opportunity to read through this agreement and seek the advice and counsel of a lawyer, and that you did not sign this under duress and you had an opportunity to read the agreement. Cool. ILA provisions there. Someone signs it. Boom. Okay. Now, what happens if in this signed agreement, some of the information is incorrect? And what if it does not favor you? So the first thing to know is a contract is always two parties agreeing to particular terms. And it is possible, and it has happened in my legal career, that I've seen two parties sign a contract. A mistake was made that didn't benefit either of them, and actually it benefits both of them to have the correct information included. And so an amendment to the agreement was made. An amendment, something really simple. It's just like you just put it at the end of a contract, of an already signed contract, say, hey, in paragraph 1, 2, and 3, we wrote this, but really what we meant to write was this, and this. And we want everything else from the original contract to stay in place, but we want to add in these other provisions and have them replace what was in the original agreement. Everyone's initials, everyone signs, we get the date, boom, done. Awesome. I love it. I'm so excited about it. There are other instances where someone will sign a contract, the information may not be correct, and in that particular case, one of the parties wants to change the information and another party does not want to change the information. And this is tricky. And this becomes very tricky because one of the first things they teach you in law school is that ignorance is not a defense. And what that means is, because you didn't know or you didn't see something that maybe you should have known or you should have seen, does not invalidate or void or disallow a contract. Because imagine what we could all get out of in our lives if we said, I didn't know. Like, think of any driving rules or pedestrian rules. I'm sure I've broken a lot of these, like where you can walk on which side of the road and at what time and this and jaywalking, right? Like there's not a law that's out there that's like, oh, you can't cross on a red, but we all know that. And I'm sure in every municipality, there's some bylaw that says that you're not allowed to do that. So the fact that we don't know about something doesn't mean that we can later say, oh, like I didn't know, so I'm not responsible for it. Especially, obviously, okay, cool, with parking tickets or jaywalking or things like that. Okay, it's relevant. I'm with you. It's there. But especially when it comes to a written contract that you had an opportunity to review and get independent legal advice for beforehand, it is highly unlikely that you would be able to say, oh, I'm sorry, I didn't know. Because, okay, you're telling me now you didn't know, but here's the signed contract and here's the provision around independent legal advice, and you are not forced to sign this contract or agreement. Therefore, it's going to apply. And now I'm going to start telling a story that's a 100% true story that happened in the past weeks with one of my clients. And it really sucks and it really frustrates me. And the reason why I'm recording this episode is because I want you to know about this information and to make sure of things. So, a lot of the times as a lawyer, I'm always working with people in one of two phases. And I know that you listened to the episode on Pay Me Now, Pay Me Later. And if not, you can go back and listen to that episode. I'm always dealing with people who are either in a proactive, secure, controlled situation, which means they invested in law up front, they have the agreements, they have everything taken care of. And if there's a problem, they're 100% in control, holding the steering wheel of the car as they're driving with the legal situation. The other time that I meet clients is when they are in a reactive situation where they've lost control of the legal situation. They're in the passenger seat while the driver is doing whatever it is that they want. And they are now reacting to the situation, trying to regain control and trying to regain a stronger legal position. It's not a good position to be in. You do not want to be in this. This is why I do everything I can to let my clients know about all the relevant information and how happy we are to support them, because I don't want you being in a situation that's out of your control where someone has stronger legal position than you. So I always find clients in one of these two spaces. In this situation, I had a client who had wanted to work with me for a bit, didn't, and then finally pulled the trigger. And then after we started working together, this issue came to a front. And this client has a hot yoga studio and they signed a lease. So far, this is a very normal story. They did not hire a lawyer or they did not ask me to review the lease for them. They just signed the lease and now they're in, and it's a 5-year term and they're locked in. Now, this is 3.5 years into the lease. My client was looking to do renovations, went through the leased space, and they realized that there's like a 300 square foot difference between what was in the lease and what they were paying for versus what the space actually was. So I think the lease said 1,100 square feet. The actual space size was 800 square feet. And the amount that they had overpaid was more than $25,000. Not a fun situation to be in. Obviously, very, very frustrating. We would hope that all business owners out there in the world, no matter what business you run, that you operate with integrity and you would acknowledge this mistake and you would remedy this mistake. Unfortunately, in this case, it didn't happen. The landlords were really, really totally against helping us, working with us, admitting anything, a lot of challenges. And in this case, my client's like, well, like, look, but it's not fair. It's not fair. This isn't the size. You know, I signed this, and all of the logical, rational arguments that one would make about why they shouldn't have to pay. And I get it. And I did my best. I put everything together for my client, and we received a response from the landlord where they said, like, firstly, the lease specifies that it's an approximate amount for the space, which is true. Secondly, your client had an opportunity to measure the space and come to us with any changes before they signed, which they did not do. Thirdly, your client had an opportunity, was not under duress, was not forced to sign the agreement, had an opportunity to work with a lawyer, contractually agreed and signed to do that. And they still signed, and they signed the agreement. And now, not only have they signed the agreement, but now, 3.5 years later, only now are they coming back and saying that they retroactively want this amount. And it's a really, really difficult situation. And I'm trying for my client as best as I can, but it's unlikely because the number's incorrect, the information's incorrect, they've been overpaying. Okay, cool. Understand all of that. But this is what the contract that was signed was for. And obviously, a reasonable tenant would actually check the spacing out on a basis of how many square feet the property is. Had an opportunity, didn't do it, still signed the agreement, now wants to get paid retroactively. It's not going to happen. And it's very difficult and it's unfair. And I tried to bring in arguments of, unfair inducement or fraud. But the more important thing to know about how the law works, the reason why you want your contracts drafted for you properly, upfront, correctly, at best practices by a lawyer who understands your industry. The actual process of disputing this agreement will be years and tens of thousands of dollars. And it really sucks that the system is like that, but that's how it works. That's really, really, really how it works. And so I'm saying to my client, like, okay, cool. This is if you default, like, she's like, okay, I'm not paying anything on the lease. I was like, okay, cool. Just so you know, they're keeping their end of the agreement. They're following the lease. If you don't pay, you're breaching the agreement, in which case all of the remedies and all of the benefits drafted in the contract in favor of them, that in the event that you break the agreement, they take over, you pay full amount, they get all the money, they get everything. So I was like, you're not allowed to not pay. Let me try to do whatever it is that I can for you. But it's going to be really difficult. And she's like, okay, well, so if I can't pay them, what can I do? I was like, okay, we can try to speak to them personally, which is what I've been doing and corresponding with them. And in addition to speaking to them personally, you maybe can, if you want, you can file a claim in small claims court, claiming that there was a misrepresentation or that the activity was fraudulent or, a false inducement into a contract based on the size. Firstly, that's just going to take years and it's going to take thousands of dollars. And your legal position is 35% at best. For this client on their respective journey, this is them learning about the importance of reviewing what is in a contract before you sign it. Before you sign agreements, please, 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 please review them. Make sure they're drafted by someone who cares about you, who cares about your business, who understands what you do, who is here to support you. Please make sure all of that is taken care of. And just be really, really careful, because stories like this for me are very, very frustrating, but I love my clients. I want to support them. I want to do everything I can for them. Make sure you understand what's in an agreement, because if the information is incorrect, it's not going to help you. In very, very limited circumstances, it may, but generally speaking, it's not going to help you. So with all of that being said, I hope that you loved this episode. If you want and you feel like it, maybe subscribe to more episodes, listen to some of the other episodes that we have, and feel free to find us on Instagram at Conscious Counsel. And I hope that you enjoyed this. I hope it's beneficial for you. I hope that you had fun. I hope maybe you were eating a delicious snack while all of this was going on. And remember, whatever it is that you do, make sure you work with a lawyer who loves you. Okay, ciao, have fun, bye-bye.